Okay, so if you're involved in Utah's felony court system, there's a term you're going to hear a lot: the preliminary hearing. But what on earth is it? Let me tell you, it is absolutely not a trial, but it's easily one of the most critical and honestly most misunderstood steps in the whole process. So let's break it down and really get into what happens at this hearing and why it's such a huge deal.
Right, first things first, let's get this perfectly clear. A preliminary hearing is not a trial, not even close. A trial, that's the main event. It's designed to figure out guilt or innocence, to get to that final verdict. A preliminary hearing? Think of it more like a filter. Its only job, its single purpose, is to answer one question. Is there even enough evidence here to bother with a full-blown trial? The goals, the rules, the stakes, they are worlds apart.
So if the goal isn't to prove guilt, what exactly is the prosecution trying to do? Well, the entire point of this hearing, the whole shebang, boils down to just one legal concept: probable cause.
So what in the world is probable cause? The best way I've found to explain it is this. If the trial is the full movie, the preliminary hearing is just the movie trailer. That's it. The prosecutor doesn't have to show their whole case, not by a long shot. They just need to show enough clips, enough little pieces of evidence to convince a judge that a reasonable person would look at it and believe two things. One, a crime probably happened, and two, the defendant is probably the person who did it. Notice I said probably. It is a deliberately low bar to clear.
And when I say the bar is low, I mean it is shockingly low. There's this key rule at this stage where the court has to view all the evidence in what's called the light most favorable to the state. What does that mean in plain English? It means the judge is basically required to believe the prosecution's witnesses. They don't weigh who's more credible here. If an alleged victim gets up and testifies, for the purposes of this hearing, their story is accepted as true. You can see how that automatically puts the defense at a massive disadvantage right out of the gate. Okay, so you get it. The goal is just probable cause, and the burden on the prosecution is super low. But what does this hearing actually look and feel like when you're sitting in the courtroom? Let's walk through the play-by-play.
The flow itself is pretty straightforward. It kicks off with the prosecution. They get up, they present their evidence, and they call their witnesses to the stand. Then those witnesses testify. And this brings us to the crucial third step. The defense attorney gets their turn to cross-examine every single one of those witnesses. After all that's done, the judge steps in and makes the final call. Is there enough here to move forward to a trial, or are the charges getting dismissed?
Now, even though this isn't a trial, and yeah, the scales are kind of tipped in the prosecution's favor, a defendant still has very specific and very important rights during this hearing. Understanding what you can and should do is key.
As the defendant, you have an absolute right to be there for every second of it. You get to sit there and hear every piece of evidence, every word of testimony that's being brought against you. And most critically, your attorney has the right to stand up and challenge all of it through cross-examination. This is your first real official chance to start pushing back against the state's story. Now, let's talk about a huge piece of advice. Your gut instinct might be to get up on that stand and tell your side of the story, right? But legal experts will almost universally tell you not to. It is strongly recommended that you don't testify. You have the right to remain silent, and at a preliminary hearing, exercising that right is almost always the smartest move. Why? Well, because the bar is so low for the prosecution, your testimony rarely helps you, but it gives the prosecutor a golden opportunity, a free shot to question you. It's a strategic trap you don't want to walk into.
Given everything we've talked about, the low burden of proof, the rules favoring the state, it might seem like this hearing is just a formality, just a hoop the prosecution has to jump through. But that could not be further from the truth. For a good defense team, this hearing is a massive strategic opportunity.
So what's the strategy? It's all about one word: discovery. This hearing forces the prosecution to show its hand. It's the defense's first real chance to get a look at the state's witnesses, to see their evidence, and to gauge the overall strength or weakness of their case. It is an absolutely priceless preview of the fight that's coming if the case does go to trial. And that preview leads right into the next step: probing for weaknesses. Look, the real power of cross-examination here usually isn't about getting the case thrown out right then and there. That's pretty rare. The real goal is to start chipping away at the prosecution's wall. A skilled defense attorney uses this as a chance to find inconsistencies in a witness's story, to point out gaps in the evidence, and to lock witnesses into their testimony so they can't suddenly change it later on at trial. And all of that chipping away, all of that poking and prodding, it can lead to the ultimate strategic advantage: negotiation. See, when you successfully expose some real weaknesses in the prosecution's case, it changes the whole dynamic of the conversation. All of a sudden, the state might realize their case isn't the slam dunk they thought it was, and that can open the door to a much better plea offer, maybe reduced charges, or just a more favorable outcome all around, without ever having to risk a trial.
So you see, the preliminary hearing is so much more than a simple checkpoint on the legal road. It's a really complex, strategic battlefield where the defense gets its first real chance to size up and push back against the prosecution's case. It really makes you wonder, doesn't it? If just one of the very first steps in the process is this layered with strategy and nuance, what does that tell us about the complexity of the entire criminal justice system?